I'm absolutely delighted that we were able to get Ron Atkey to come to speak to us, and at a perfect moment in the Law and Social Change Policing course. But even if it hadn't been a perfect moment in terms of our syllabus, it's always wonderful to sort of have a chance to listen to Ron. Sort of a quick run through of all the stuff that Ron has done over the years. He was Conservative Member of Parliament twice, including being Minister of Employment and Immigration under the Joe Clark regime. So after a sort of a political career like that, he somewhat left politics to join the law firm of Osler, Hoskin, Harcourt, where I believe you still are. No, he's not
Retired.
Still there. I'm sorry, where are you?
Retired.
Oh, retired, except it doesn't really seem to me like you're retired. So, anyways, doing an array of law still. But for our purposes, or one of our purposes, perhaps the most relevant aspect of his career is the fact that he served as the chairman of SIRC, the Security Intelligence Review Committee, that is set up to oversee CSIS, unlike any equivalent organization overseeing the RCMP. Has, of course, been involved in varying inquiries, including the Arar one, amicus curiae. Maybe he'll sort of explain what his role was in terms of the Arar Commission. And retired or not, he's been deeply, continuingly to be involved in issues related to national security. And I didn't realize, maybe you told me and I forgot, that you'd actually wrote a novel at one stage. We all sort of fantasize about the novel that we spin off that then brings us sort of fortunes into our retirement. I won't ask you whether
that didn't happen. That did not happen.
Apparently it didn't happen. It's called The Chancellor's Foot, so you might sort of be interested in tracking down his novel. So, again, I'm very, very pleased that Ron Atkey could join us, and please welcome him.
Well, thank you, Margaret. It's a pleasure to be here on the first day of spring and to join you in a classroom where you probably would prefer to be outside and enjoying this weather. I don't know how long it's going to last, but it's really quite marvelous. It's also a pleasure to be accepting from the Nathanson Center. You may have heard of that. Margaret used to be a director, a fellow called Craig Scott, who's gone on to great and glory as of yesterday, leading the Orange Wave in Toronto Danforth, was a former director, and current director is Francois Tanguay-Renaud. It's on their behalf that I'm here, basically to share some thoughts about Canada's national security. Now I say I've come back to Osgoode because some of you may know that I do hang around here in the fall as an adjunct, and I give a course in national security law. Margaret did forget in her introduction that I was a professor of law at Osgoode Hall Law School from 1971 through 74. And Western before that, as a full-time professor. I should acknowledge also that some of my remarks today form part of a paper I gave to the International Forum on Crime, Criminal Law, and the Global Era, which is a Chinese-based organization in Beijing, which Margaret and I have participated in, and which has been supported by the Nathanson Center. But I thought about my first time at Osgoode when I was preparing my remarks for today, and historical comparisons between then and now. And let me set the stage for you. There was a gentleman called Pierre Elliott Trudeau, also a law professor, who had just been elected as Prime Minister in 1968. He'd achieved a strong majority government then, basically on the perception that he was able to stand up to the FLQ, the Front de Libération de Québec, which is then our most prominent group of homegrown terrorists. And this was borne out, of course, in 1970 when the FLQ and murdered the Quebec Minister of Labour, Pierre Laporte. They kidnapped a British diplomat, and they launched a series of mailbox bombings which frightened and terrified everybody. And as students of Canadian law and political history, you'll remember Trudeau's invocation of the outdated War Measures Act in 1970, where they sent in the Canadian Army, and in the streets of Montreal they rounded up some 400 people, alleged separatists. Few of them were ever charged with anything, let alone convicted. But it was a time of dealing with our then group of homegrown terrorists. Okay, now let's flash forward 15 years from there. During that period of being at Osgoode, and I, like Craig Scott, was a full-time professor of law when I got elected to Parliament and the next day, and had to tell students we'd have to sort of rearrange the schedule, and I extend my congratulations to Craig. He'll make a significant contribution to the quality of debate in Parliament. But I was running as a Conservative, running under a fellow called Stanfield, and then Clark, and we were essentially running against Trudeau. And I had also, during this period, become comfortable at a downtown law firm called Osler. But in 1984, I got a call from the Prime Minister's office, a fellow called Mulrooney, who I had not supported. And his office said, "How'd you like to become chair of the first watchdog of Canada's new security service?" And I didn't know whether this is a plum or making me go away or what was involved, but I thought it sounded interesting, anything to do with being a lawyer or the new charter, which was then coming into place. And they said, yeah, it's got some relevance, but go and have a look at the background material. So I went into a law firm that weekend. We didn't have home computers in 1984. So I read the CSIS Act, and I found the whole thing quite fascinating, you know, created by the MacDonald Commission, in effect, of inquiry, which had looked into wrongdoings within the RCMP. The late Justice MacDonald was a very prominent and able Alberta judge. And the Canadian Security Intelligence Service, CSIS, had just become our first independent spy agency in Canada. But I also learned, I read some of the history, I said, did we have nothing before then? Well, security intelligence in Canada goes right back to Sir John A. Macdonald in the middle of the 19th century, even before Confederation. It was tightly controlled, and then it evolved into the RCMP, which had some kind of responsibility in this area through to 1984, and some of their activities in the 70s in chasing down the separatists led to the alleged barn burnings and some of the other things that led to the MacDonald Commission. But set the scenario in the history, the story really doesn't end with that appointment as the first watchdog, or as chair of the first watchdog of CSIS, because we'd only been in office 7 months. And then there was the worst terrorist act in Canadian history to that point. The bombing of Air India Flight 182 through explosives placed by militant Canadian Sikhs in Vancouver. The murder of 329 Canadian passengers and crew over the Irish Sea. 2 baggage handlers killed in Narita Airport near Tokyo following the arrival of an Air India flight from Vancouver containing similar explosives. So that was a bit of a jolt. We're right into the game. Things were beginning to happen. This was 1985. Now, as a watchdog of CSIS, we immediately had 2 questions. How could CSIS have missed preventing this terrorist act, since they'd been targeting Sikh extremists in the West Coast for some time? We'd had briefings on that. And was CSIS focused too much at the time on areas other than terrorism? Were they spending too much time watching the Soviets or the Chinese through espionage activities that were alleged to have occurred and which dated back to the days of Guzenko? Well, the first question is, what went wrong? Why did CSIS miss this? That one took 25 years to resolve, maybe still not resolved, but there were many reviews, many inquiries relating to the destruction of tapes by CSIS. lack of cooperation between the RCMP and CSIS, operational bungling, failed prosecutions in British Columbia, and government cover-ups. The Commission of Inquiry, led by Justice John Major, which eventually got to the bottom of things in 2009, did the best job possible given the extensive resources that were made available to him. And I would commend that report to you, and I don't propose to go into that today, but it makes it excellent reading. But the second question that we were faced in 1985, and this involved only CSIS, which was our jurisdiction. We had no jurisdiction over the RCMP or the other municipal police forces or provincial police forces. It resulted in an immediate and significant rebalancing of resources and mandates towards anti-terrorism, which had been lower on the radar scale at that point, and a lessening of the anti-espionage mandate. And I'll come back to that. But the point I want to make for today's purposes is that terrorism was being dealt with long before 9/11. There were, of course, involvement of the RCMP. And under the CSIS Act, this body had powers to engage in electronic surveillance, intelligence sharing with our allies, running of sources or paid informers. And this, combined with criminal law enforcement by the RCMP and the other police forces, continues to serve us well in preventing threats to the security of Canada. And thankfully, we've avoided any major ones so far in this country against Canada. Now let me go into the events of 9/11. September 9/11. You are all probably playing the game as we did. Where were you when President Kennedy was shot? Well, you probably played the game. Where were you when 9/11 occurred? Were you watching television? Were you in class? Were you out at a party? I think it was in September. Nice night, nice day like today. Canada had anti-terrorism laws in place prior to 9/11. They were essentially part of our domestic criminal law under federal jurisdiction. We've always had criminal law offenses for murder, sabotage, causing bodily harm, and more recently being a member of a criminal organization. And in addition, we've had what are called inchoate offenses: attempting, conspiring, counseling, aiding and abetting, and being an accessory, all of which are capable of outlawing most of the actions on the periphery of an actual terrorist act. And we also had, many people don't realize this, but we had international anti-terrorism obligations governing crimes involving nuclear materials, crimes against aircraft and airports, maritime navigation, and internationally protected persons, as well as hostage taking. That was well before 9/11. But the events of that day had profound effects not only on the United States, but on Canada. Not only were the destruction of the Twin Towers close geographically to Canada, 1 hour's flight from where we are, but 24 Canadians lost their lives in the towers, along with the 3,000 Americans in the Twin Towers and at the Pentagon. Canadians at Halifax and Gander provided safe haven for thousands of U.S.-bound travelers for several days while U.S. airspace was closed. And at the time, I was working in 1st Canadian Place at Osler, the tallest office tower in Canada, and we were evacuated that day because of concerns that the terrorist acts, this was short-term thinking, but they might be extended to major targets in nearby Canada. So it had a personal involvement if in effect you were there. Now, all of the legal scholars, all of the brains in the Department of Justice, and all of the political leaders in Canada at that time recognized that Canada's anti-terrorist regime lacked heft, and it badly needed updating and expansion. And there followed a flurry of new measures introduced and passed by the Canadian Parliament in record time during the fall of 2001. And I'll just give you a summary of a few of them. There was the speedy implementation of the regulations under the United Nations Act relating to making terrorism, financing a crime, suppressing terrorist activities, adopting sanctions against Al-Qaeda and Taliban. But more important was what became known as the Anti-Terrorism Act, Bill C-36, which contained a lot of new measures adding to our criminal law and becoming a permanent part of the criminal code, not as emergency legislation, and very much subject to the Canadian Charter of Rights and Freedoms. And I'll go through a few of the key measures. There was a definition of terrorist activity, causing death or serious bodily harm, endangering a person's life, causing a serious risk to health or safety of the public, causing substantial property damage, and causing serious interference with essential public services. But there was an exception. Unless those activities were part of advocacy, protest, or dissent, this does not harm the public through violence or cause substantial property damage. And to secure a conviction under the definition, the prosecution has to show that the terrorist activity was intended to intimidate the public with regard to its security, either physical or economic. And of course, the generic definition also included a number of inchoate offenses such as conspiracy, attempting, threatening, accessory, or counseling. There's an important exception, and I won't go into it today. It's a subject by itself, an exception for acts committed during an armed conflict that are in accordance with customary international law or conventional international law applicable to the conflict. Those are some of the issues that, if you're examining the conflict in Afghanistan, you might want to address. The Anti-Terrorism Act, which still exists, includes the definition of terrorist group, which can either be an entity or one has the purpose of carrying out a terrorist activity, which I described. And we've already got a number of well-known groups listed: Al-Qaeda, Taliban, the Tamil Tigers, Hamas, Hezbollah. The listing and delisting process is in the legislation, and it's complex, and all I can do is summarize and say it's easier to get on the list than it is to get off. And if you ever have a challenge for somebody who's on the list wanting to get off, you've got yourself a 5-year retainer, I think, going ahead in the law. The Anti-Terrorism Act also denies charitable registration under the Income Tax Act to organizations financially supporting terrorist groups, and it creates new terrorism offenses related to financing and property. And then again, there are the new inchoate offenses related to terrorist activity: instructing, harboring, providing reconnaissance for terrorist groups, etc. And in a departure from the normal criminal law that applies in Canada, the Anti-Terrorism Act contains provisions extending extraterritoriality to most of the terrorism-related offenses. The Anti-Terrorism Act contains 2 controversial provisions, and it contained at that time related to investigative hearings and preventive detention for those persons allegedly engaging in or suspected to be engaging in terrorist activities. These measures were made subject to a 5-year sunset clause and therefore expired in 2007 when the minority government was unable to secure the approval of Parliament to the continuation of the measures. However, I can tell you that the current Conservative government secured a majority in May 2011 and has since indicated that we'll reintroduce these measures. Essentially, they're designed to foil terrorist activities before they occur and could result in a person being detained for a limited period of time, 72 hours, can be worked out under the provisions, without being charged. And that's quite significant in our criminal law, being held for 72 hours without being charged on mere suspicions of terrorist activity, not even necessarily criminal activity. In my view, these measures, with appropriate safeguards, will probably be accepted by the Canadian public as a form of insurance against both domestic and international terrorist activity post-Bin Laden. But I'm not sure that the wholesale acceptance by the Canadian public is necessarily a good thing or is a part of the necessary evolution of our criminal law going forward. Again, another subject for separate debate. I want to talk about successful prosecutions under the Anti-Terrorism Act. They have been few in number, but there have been significant convictions in major cases. I'm just going to talk about a couple of them. First, there were charges which you've all read about in the papers here in 2006, cases known as the Toronto 18, arising from the uncovering of a major plot among domestic terrorists to blow up important sites in downtown Toronto, such as the Toronto Stock Exchange, the regional headquarters of CSIS, and some other prominent buildings. Convictions were eventually obtained in 11 of the 18 cases, and in serious cases of imprisonment were imposed. In 7 of the cases, charges were stayed by the prosecution because of the absence of reliable evidence or related matters, such as the youth of some of those charged. These were quite youthful persons being charged as part of the Toronto 18, and that figured into the negotiations as to how they should be disposed of. The other important case I want to mention is the conviction of an Ottawa man called Khawaja. And you'll see a variety of cases in our reports of the courts. Khawaja was working, and his charge was working in concert with members of a terrorist group in the United Kingdom. That case occurred in Canada against Khawaja because he was living in Ottawa. But most of the activity which led to criminal convictions were in 2007 in the United Kingdom under their equivalent law. So in a way, that was a sort of an associated case which didn't have just exclusively a Canadian nexus. Now in the Toronto 18 cases, there were 2 features that you don't always hear about. First, a lot of the credible evidence leading to the 11 convictions in court came from a so-called member of the terrorist group who turned out to be a paid informer working for CSIS. It was eventually revealed that that informer was being paid more than $4 million for his work, a sum that included new houses for him and members of his family, new cars for him and members of his family, payment of debts, and an ongoing income stream, and possibly assistance in changing his identity. And it's a debate as to whether we got value for our $4 million as taxpayers. Certainly prevented a horrible series of acts from occurring, secured convictions. I think the balance of public opinion is that it was a lot of money, but probably necessary under the circumstances given the ultimate result, both in terms of convictions and the prevention of a terrorist act. The other part of those cases involves some of the decisions of the trial judge, Justice Fletcher Dawson, and the relationships between CSIS and the RCMP, who had conducted separate but distinct investigations. They did share information, but the investigations were not so interwoven as to constitute one investigation. And the purpose of this was meant that CSIS wanted to keep their intelligence related to the cases away from disclosure to the accused in the criminal cases, because CSIS is always reluctant to disclose its sources and methods of operation in an open court context. If you're acting as defense counsel for one of the accused, you might think otherwise, and there's a very healthy debate goes on as to what is the particular wall or veil that exists between the organization. Only the evidence that CSIS considered not to be privileged was to be disclosed. And the court made a finding that intelligence agencies gather information for a different purpose than law enforcement agencies. They gather it for under a standard that is not required by the courts in criminal cases. And that distinction has so far stood up. The Supreme Court of Canada may weigh in again on the other matter. In the Sharkawi decision, the Supreme Court of Canada has required CSIS to keep all its information, all its notes, in the event that some of its intelligence collected might have to be disclosed as evidence in case. And the clarification of that particular Sharkawi decision has not been fully fine-tuned and nuanced by the court as to be fully operational, and there's some healthy debate going on between CSIS and the RCMP, and the court will probably weigh in again. Okay, we come now to 2012. It's 10 years after 9/11. What's changed? What are some of the new things we were going to be looking at? I've already signaled there will be the reintroduction of investigative hearings and preventive detention, and that's coming. And there will be supporters and there will be opponents, and it's a healthy debate in Parliament. But at the end of the day, the majority government will have its way, and those will become part of our law going forward, with or without a sunset clause as they had in their first instance. The second thing to focus on, and it had some publicity, is the new security perimeter agreement with the United States, which recognizes the importance of the sharing of screening techniques and methods of operation with our most important trading partner. And we are already seeing aspects of that being introduced in terms of security vetting that goes on at our border points and at our airports. And you'll see more of that in terms of security screening that goes on within respective countries. And you can bet that the country that is the largest will establish the rules, and Canadian rules will bend to US standards and procedures. The third thing that's new since 10 years after 9/11 is there's going to be more emphasis on homegrown terrorism. And I'll come back to that. Let me take a few minutes then to give you some background and some personal observations and predictions, and to raise some questions for our policy makers related to national security. I generally, like others who work in this field, favor a whole-of-government approach to national security, suggesting that involves a lot more than counterterrorism. I think we should have a coordinated approach involving many agencies at the federal, provincial, and municipal levels to deal with natural disasters, pandemics, damage to our critical infrastructure, other forms of terrorism than that which occurred on 9/11, and yes, let me mention counter-espionage. And we're coming back to that. Well, let's first start at the top of that list. Justice John Major in the Air India inquiry stipulated that he would like to see a national security czar in Ottawa, somewhat independent of the Prime Minister, to coordinate the national security activities of the 23 federal departments and agencies that have a role in this field. Everything from air transport to immigration to border services to emergency preparedness. And of course, premiers in the provinces, and certainly the major provinces, and mayors in the major cities would be well advised to have a structure in place as well. So that's in terms of government structures. Secondly, I'm going to suggest the radical thought, and maybe it's not radical for Canadians, to suggest that climate change has created threats to our national security through potential natural disasters, whether it's earthquakes in British Columbia, flooding in the prairies, ice storms in Ontario and Quebec, hurricanes in Atlantic Canada. Take those instances, throw in some potential man-made disasters like major railway or subway displacements, pipeline ruptures, sabotage of pipelines, nuclear accidents, offshore oil spillages, and I think you've got an inventory of threats to our security that should be taken seriously. Some would say that's not part of national security in the narrower context, but I would suggest in the whole of government approach, it is national security. And then what about pandemics? How many can remember 2003, the SARS crisis? It's certainly most of us who were in Toronto at that time, we were very much affected by it, and access to our hospitals and our various institutions. It's the killer virus brought from Canada. And I don't think, when you think back to that, there's any doubt that pandemics can constitute a threat to security taken in the broadest sense. The fact that a few years later the federal government overreacted to the H1N1 threat by ordering excessive amounts of vaccine, I think that's readily understandable and far preferable to not ordering enough had the potential pandemic materialized. Potential damage to our critical infrastructure. We haven't thought about that too much. I don't think there was even a list of what our critical infrastructure was in 2001. But think about what we have in Canada. What are our assets? You know, it was ironic that we really found out more about this from WikiLeaks. When the US memo was released in December 2010, and it was a US diplomatic cable listing an inventory of key Canadian infrastructure and resources required and considered vital to US residents. And there were 34 items listed, 4 key bridges in Ontario. Just think about it. The Blue Water Bridge, the Ambassador Bridge, the Peace Bridge, and the Ivy Lee Bridge carry 70% of Canada's two-way trade with the United States over those 4 bridges. A lot easier to take those 4 bridges down if you really want to hurt the United States and Canada than some of the people projects that have been discussed. The natural gas transmission facilities from Western Canada came into prominence in that list. The major British Columbia dams to facilitate hydroelectric power going to the US, they were listed. The test for being on the list was sites whose loss would critically impact the public health, economic security, and/or homeland security of the United States. And presumably today, I suspect a similar list exists in Canada of our infrastructure from a Canadian perspective. It's not a public document, and the US document wouldn't be public but for WikiLeaks. I have some understanding that there was not a list of Canadian infrastructure available in 2001 when it was asked for. Now let me state some of the more obvious observations about current terrorist threats in Canada and other Western countries. And I'd suggest to you that it's not Al-Qaeda or the Taliban operating from Afghanistan or Pakistan. Yes, they are a threat, but it's not the main threat. Suggest it's perhaps homegrown terrorists like the Toronto 18, young, misguided hotheads who may take their inspiration from Islam and their guidance from international Islamic terrorists, aided and abetted by easy access to the internet and social networking, and not scrutinized carefully by parents and community leaders. And like any terrorist movements we've had in Canada, and I've been through and seen a few, the IRA, the PLO, Sikh and Turkish extremists, Chinese Kunglok, Jamaican Rastafarians. It's the community leaders in these organizations which are at the heart and can be most effective at preventing terrorist acts from occurring. CSIS does work within this reality, and they are taking steps they can without being terribly visible. And we'll see how effective that may be. I was encouraged on February 9th this year when the Minister of Public Safety announced a new comprehensive counter-terrorism strategy focusing on homegrown terrorists, emphasizing the need for greater coordination between the key agencies, and he named them the RCMP, CSIS, Foreign Affairs, CEDA, and the Armed Forces. And he mentioned for the first time a number of vulnerable communities in Canada, such as Somali Canadians. But there's another form of homegrown terrorism, and it's not unique to Canada. It's what the police and the security services call lone wolf terrorism. We've seen it in the United States, in Norway, in France just this week, and yes, with Marc Lépine at the University of Montreal some 20 years ago. No longer is this regarded as the mindless, unpredictable act of an isolated, deranged person. Often the devotees of these causes range from white supremacy and anti-capitalism to animal rights and environmentalism. And we are also identifying in our communities warning signs such as incidents of bullying, depression, abnormal behavior in schools or the workplace. And people are becoming encouraged to come forward to school authorities, to employers, to the police, and to parents when they are unusual and they see unusual and dangerous behavior. And CSIS and the police work within this reality as well. So I'm going to conclude before we take a break with a couple of recent things that have come to light in the security intelligence and the national security field. Let me conclude first that the government response to unfortunate individuals caught up in the system will be less sympathetic going forward than they have in the past. I don't think it's just the conservatives and the liberals. I don't think it's necessarily a political party thing, and I'm not sure it's an ideological thing. It may be just a reflection of the times when security of the whole society trumps individual security. And for me, this is sad, and I think it's a step backward, but it's a reality. I have to say it's unlikely there will be another O'Connor Commission dealing with somebody like Arar, or a Yakabuchi Commission dealing with the rights of al-Malki, al-Mahdi, and Nuruddin, 2007, 2008. I think the RCMP and CSIS will be given greater latitude to do what is necessary under law to protect all Canadians against legitimate threats to the security of Canada, even if that means individual rights are diminished. That's where your role as lawyers going forward are particularly important. Another example of this is the revelation last month of the federal government's directive of December 2010 to use information provided by foreign agencies that may have been extracted through torture in exceptional cases where Canadian public safety is at stake, as long as the Minister of Public Safety is notified. Let's call this the Canadian defensive strategy. Normally, you will have learned in your criminal law and my course in national security that use of information obtained through torture is not permitted. It's illegal. This issue is going to be played out in the federal court and the Supreme Court of Canada in the context of Sections 7 and 1 of the Charter. And whether the admission of torture evidence in exceptional cases is a violation of due process rights of the affected individual of the Charter, that's going to be in issue. The issue is not behind us. Perhaps even more disturbing was the revelation on March 3rd of this month of a 4-page directive from the Public Safety Minister to CSIS in July 2011, giving the go-ahead to provide, this is the offensive strategy, to provide information to foreign agencies even where there is a substantial risk it will lead to torture. And remember, it was the RCMP who provided questions to the Syrian authorities that led to the torture of Mr. Arar for a period of 9 months, and for which they were soundly criticized by the O'Connor Commission. The directive rightly acknowledges that Canada does not condone the use of torture and is a party to international agreements that prohibit torture, but it states, and I quote, "Terrorism is the top national security priority of the Canadian government, and it is essential that CSIS maintain strong relationships with foreign entities and share information with them on both a routine and urgent basis. In most cases, it will be up to CSIS to establish the internal approval rules, proportionate to the risks in sharing information through foreign agencies that is routinely engaging in torture. Although the CSIS director does not have to refer the decision to the minister to consider in the light of Canada's legal obligations." This kind of all seems pretty circular to me, reminiscent of the kind of legal analysis that came out of the White House justifying the torture memos under the Bush administration, and which continues under the Obama administration, and the legality of torture.
You decide, Ron, when you want to.
I'm going to just deal with one other issue, and then we'll come back for questions. How's that, Margaret? And this is the issue of espionage. I had referred to this earlier and said it had been diminished and deprioritized, and we had come up with a greater emphasis on terrorism. But, you know, espionage is back. What goes around comes around, or as they say, plus ça change, plus la même chose. The Russians are about one example. Many within the security community, including CSIS Director Richard Fadden, would say that espionage has now rebounded to Cold War levels, and it's much harder to deal with espionage because of the multiplicity of players in the game. Chinese commercial interests are in the forefront, not the government. And many in the security community sort of long for the good old days when they knew that the enemy was the Warsaw Pact and the Chinese government, and that was about it. But it's become more complex. And I refer just to the Russian initiatives where they appear to be up to their old tricks. They found a complicit Canadian, in the name of Jeffrey Paul Delisle, who's a young junior intelligence officer in the Canadian Navy's Trinity Centre in Halifax, and he's been charged under the Security of Information Act that became law just after 9/11, replacing the old Official Secrets Act. He's the first person charged under this act, and he's accused of giving a foreign entity secret information between 2007 and 2012, likely, and the speculation is, naval intelligence concerning the movement of Allied ships and submarines. Now watch the trial of this fellow. Some of it will be in open court to see if he asserts charter rights and whether the Security of Information Act will stand up. More important, of course, is the retaining the trust of our American and British naval allies. And many journalists are speculating that the security fallout may be worse than the crime. So those are my formal remarks, Margaret. Perhaps we can take a health break for 10 minutes and then come back for some questions.
Perfect. Thank you very much. Thank you. Do you want to say anything before we open?
No, I'm glad to have questions. I'll tell you everything that I'm able to tell you.
Without killing us.
That's right. I do want to talk about the book that is no longer for sale, so it's not a commercial pitch. But when I wrote The Chancellor's Foot,
is it no longer for sale?
I think you can buy it on the remainder shelf somewhere.
Oh, okay.
But
Amazon, I'm sure.
yeah, but it was a difficult decision to make as to whether you wanted to write something in nonfiction or fiction. And I had adopted, I guess, some of the techniques that other spy writers had written, is that you can tell more truth through fiction. And so I chose to write the book in a fictional account. But there were, and of course with the usual disclaimer at the beginning, there's no similarity between characters living or dead. And of course everybody bought the book because they wanted to see if they were in it, even by another name. But what it was about was the Chancellor's Foot. Now, those of you who studied legal history will know that we had courts of equity, we had courts of common law, and the courts of common law were certain and predictable, and we all worked within that. The courts of chancery were equitable. Some would say discretionary, some would say arbitrary, and it was the English writer John Selden who used the term that the court of chancery operates like the length of the chancellor's foot. Some chancellors have a long foot, other chancellors have a short foot, some chancellors have an indifferent foot. And having spent a few months in the Department of Immigration as minister, I thought that was maybe the best way to describe how I saw that department operating, based on who screamed the loudest and who paid the most. Wow. So it was a revelation to me, and things have improved considerably since I was there. But that's what
you think things have improved?
I think so.
Just in the news last week or the week before, well, it had to do with refugee claims, I guess.
Yes.
They did an analysis of what claims came in front of what person, and somebody had never okayed a claim, whereas somebody had okayed something like 80%. Seemed a bit arbitrary.
Yeah, the tribunal continues to need reform, and there has to be care exercised in who's appointed.
I've got the microphone. Who would like to ask a question? Yes,
I'll
James.
ask a question. I guess I
think you
should
need
speak
to
into the microphone so that it's
I'm not
recorded.
certain how it goes on, so maybe you can.
Is it working? Okay. Thanks very much for that, Ron. I really enjoyed it. I guess the question I have for you, post 9/11 and our Anti-Terrorism Act, is, in your view, in light of your experience, did we really even need the act? I mean, it sounds like we had all the tools from a legal standpoint, and as did the Americans, by the way, to stop the terrorist had we obtained the information in advance. It was a failing in intelligence as opposed to a failing in, the legal tools necessary to combat the problem. Do you share that view, or do you think the tools that have been added are necessary?
I think
tools?
in technical terms, we probably had the existing tools in our ordinary criminal law. And added to that the powers under the CSIS Act and under the RCMP legislation to do what they do, and that is policing and security intelligence. But there are two factors at work. First of all, I think the convictions that were attained in the 11 and the Toronto 18 did involve some of the new legislation. And so proof of the pudding is in the eating. We got convictions between they had that legislation. Ergo, had we not had that legislation, would we have got the convictions?
We probably would have gotten convictions for conspiracy at least, though, and attempt.
Perhaps. But there is the argument made that because of that legislation, we got the convictions. The other thing is perception here. And we're dealing with our friends, the Americans. And with a massive intelligence agency in Department of Homeland Security, and now about to enter into a North American perimeter agreement. There is the expectation that we would do something. We, first of all, implemented the UN conventions and regulations, but they said, you got to do more. You need a Patriot Act. You need something. The UK is doing it. France is doing it. Germany's doing it. Canada, what about you? So there was a political need to appear to be doing something. And I said, I don't think it was ideological. This was the Martin government and then the Chrétien government at the time. So I think there's a fair element of that. And that still prevails today. I think the reintroduction of preventive detention and investigative hearings and some of the matters we've engaged in regarding the use of torture in some extraordinary circumstances, that's almost stuff that's drafted out of the State Department or out of the Department of Justice in the U.S. And,
can I just ask a follow-up question, too? So just getting into the torture question, and you did a really good job of explaining to us how we're lowering the burden in terms of facilitating the use of intelligence that may have been obtained through torture. Torture is a crime in Canada. It's something that's recognized internationally. We subscribe to international treaties that require us to prohibit it domestically. Couldn't one make an argument that if we're knowingly facilitating the transfer of information, we're transferring information that we know might facilitate the crime of torture, by doing that we're parties to the act of torture? There's a reason we have that prohibition.
If a minister of the Crown gives an interpretation and it gives a directive to CSIS that they should not totally exclude torture evidence in every case, but consider its possible significance, which is what the position CSIS wants. Or if the Minister of the Crown directs CSIS to provide questions to question these guys being held in Guantanamo, Kader, for example, you have this whole notion of sovereignty of a nation and who's going to make the ultimate decision as to legality. The Supreme Court of Canada in Cotter stopped just short, where they said, you know, we think it's wrong for you to provide questions or participate. You were complicit in the torture that took place in Guantanamo of Cotter, who was a Canadian, but we're not going to go the ultimate step and provide the remedy. That's reminiscent of the U.S. presidential executive order. And I'm afraid to say that's where we seem to be drifting as we align our laws in Canada with that exists in the United States. And I don't know what's happened to this whole notion of parliamentary sovereignty and this sort of thing. Who's going to intervene? Is Parliament going to intervene? Well, Parliament usually reflects what the majority view of the people of Canada is, and I think the people of Canada say in extraordinary circumstances torture should be used.
Hopefully Craig Scott will have some impact.
Well, I think so, but there is this notion of the legal obligation and the public will, and the differences between the two, and that's the situation we find. And I think Craig has an extraordinary opportunity to make a contribution to the debate if he's listened to.
I agree with you, thanks.
Another question? Yes?
I guess just to actually follow up on what was just said there, is there really such a hard line between providing information to foreign authorities that may lead to torture and Canadian national security? In your view, is there another way, another approach that we can take without being complicit in this kind of activity?
Having sat through a couple of years of the Arar Commission hearings, and you listen to the justification of RCMP and CSIS saying, well, we just provided these questions and we gave them through proper legal authorities in Syria, and you know, they're going to put the questions to them, and we're not engaging in the torture. We've seen the guy, we're having our consul visit him on a monthly basis. They didn't get the full story. All they had was that Syria didn't come out very high on the list of countries that don't engage in torture. It has a historical track record. So there's a question of judgment that somebody has to make. And who do you give it to? Do we give questions to the Americans? Well, they're our allies, they're our best friends. Why wouldn't we give them questions? But they engage in torture. And they do. So that sort of poses the whole question. You do, as a sovereign country, either under your own legislation or under direction from your minister that is legal, that which you think is in Canada's national interest. And if it's in Canada's national interest to help the Americans by giving questions to pose to an alleged, now convicted terrorist at Guantanamo, then we'll do it. There are still many within the RCMP and CSIS who believe that Arar was a terrorist. And they will not accept the facts and the situation. I think the only evidence that was eventually adduced against him, and it was pretty shaky evidence, that he attended some kind of training in 1992 in Pakistan. But there was no evidence. It was all based on circular kind of suspicions. Somebody puts it in a memo, and then it gets picked up by a memo, and then it gets exchanged with the department and this sort of thing, and it goes around in the intelligence sharing, and then it was shared by the RCMP with the Americans, and then they deported him, or extraordinarily rendered him. And so this is not an exact science, and it's the whole question of management. And you have to have some faith in the director, you have to have some faith in the minister, and you have to have some faith in the accountability mechanism that exists for a particular institution. The fact that CSIS has a CERC, a review body, a watchdog, I think is seen as a good thing, and they have people who, and staff, to comb through this thing and make sure that there is compliance with the law. Not all agencies have that review body, as Margaret has pointed out.
Right. Thanks.
Yes.
You talked briefly about Bill C-36, the Anti-Terrorism Bill.
Mm-hmm.
The most recent Bill C-10, the Omnibus Crime Bill, which I believe passed a week ago,
Mm-hmm.
included a terrorism provision that allowed citizens of Canada to sue certain foreign entities based on the approval of the Canadian government to allow them to sue. Do you see this as another sort of, they already have a certain limited right, this is just a way to assuage those terrorism concerns? Do you think this is a meaningful change? And do you think it's important that the government still reserves the right to deny these suits action? Do you think that it actually provides anything?
I think it's political window dressing. I don't think it'll ever amount to much. I think it'll be the rare case where the government of Canada will consent. Where they do, it's where there's widespread public belief that this is a state like Libya or other places, and they have assets and resources frozen somewhere and they can be made available. So it becomes a bit of a political football. But as a practical provision, I don't think it has much significance.
Could I just ask the IT man, when Ron doesn't speak directly into the microphone, do you think it's being picked up okay?
Margaret?
Oh, you're wired for sound, sorry. I was just afraid that we were missing your words there. Yes, over here.
Maybe I should worry.
I'm sorry, and then there was a question over here
Okay.
too.
You mentioned that you thought that the new greatest threat in terms of terrorism was homegrown terrorism, and you talked about ways to combat it being things like community leaders and preventing, watching things like bullying and depression, things that are really grassroots. Do you see the need for a continued, really strong intelligence-led policing presence, or is it more about the local municipalities, the police forces there? And if that's the case, do we really need a continually burgeoning police budget or CSIS budget based on national security intelligence?
I think you need both. I mean, the local policing authorities do a good job. I'm for the most part, community policing that's done through our own Toronto Police Service, for example. But CSIS has certain expertise, and they can target particular groups. They have an intelligence basis of information. They collect information from the UK and the US. And they know more about the organization. They have people who are dedicated to going out into the communities and talking to the imams and to talking to parents and community leaders and spending the time. And they're not visibly police officers. They're intelligence officers. We no longer have the days when CSIS were identified sort of spooky individuals hanging around the corners without a business card and without a name. It was, you couldn't get their names about 4 years ago, and then we finally got their first names, and now I think the policy has changed. We have their full names,
Yeah, right on it.
and the CSIS and the CSIS logo, and this is long overdue, and it's part of a security intelligence agency, which is it's a bit of a conflict in terms, but it can be transparent, and if there's any doubt as to what they're up to, they should refer to the CSIS Act. And the CSIS Act is quite a broadly drawn piece of legislation with a lot of specifics, and it's quite extraordinary among Western countries to have your own security intelligence agencies established under a statutory mandate which is available for the public to see. So I think there's a role for both. Sure, there are budget cuts, but I don't think the elimination of one or the other. I think coordination is important, and you don't want duplication. Just to divert a little bit in terms of lack of coordination, we saw it on a subject that is near and dear to my heart, along with Margaret and James and several others, is what occurred in policing operations in June 2010 in the G20 policing operation. And that was a bit of a mishmash because of lack of coordination between various levels of authority.
Yes. Something, yes.
Well, I was actually going to say something similar, just with respect to in the past few. Just with respect to in the news the past few weeks, there was a woman saying that some CSIS agents had come to her work on numerous occasions. So then I think they made an analogy that, you know, now you have CSIS that are sort of, are they taking over the duty of police officers? So just wondering if you had any comment on that. But I think you did comment on
Well, I think one of the 4 important functions that CSIS is asked to perform under the legislation is to conduct security assessments. And that's any senior public servants or doing some of the stuff I do have to have a security assessment, and they have various levels of clearances. Some defense contractors and others. Who's going to do these security assessments? Are they going to be police officers who look and behave like police officers, or a paid, a well-trained security assessment officer who goes in civilian clothes and talks to people? And to have a security assessment, you have to have 3 people that they have talked to who are friends or neighbors or other, and a close-by neighbor, which is a 4th. And they have to have a personal conversation with them. And they're trying to root out, not the usual, you know, working for the Soviet Union or Russia or China, this sort of thing, but do these people have problems? Do they have financial problems? Do they have marital problems? Do they have gender issues and addictions that would make them subject of being vulnerable to blackmail? I tell the story about the issue of homosexuality in security assessments. CSIS used to be very concerned about homosexuality and said all homosexuals could not get a security clearance. And that rule was challenged rightly. And so the policy now is on a security assessment. If you're gay and you're out of the closet and everybody knows about it and you're not trying to hide it from everybody, you can be security cleared. But if you're in the closet and you're not sharing this with family, friends, and colleagues, then you could be subject to blackmail, then you may not get a security clearance. And it's those issues which somebody's got to talk about, who knows that person, and who are you going to have to perform that task. And so, for better or for worse, we have CSIS do it under the security assessment provisions.
Yes. Yep.
I guess my question is, since the McDonald Commission, there have been a series of developments where attitudes with respect to CSIS's view of intelligence versus the RCMP's view on evidence, and indeed other policing forces' views on evidence, sort of ranging from the McDonald Commission to the excessive siloing that seems to have led to potentially the Air India bombing, to Stinchcombe, to Charcouy. Mm-hmm. Is one of the findings coming out of the major commission referred to, it might have been section 19 of the CSIS Act, I'm not sure, but it seems to change the ability of CSIS to share information almost to an imperative where there's information that's relevant to a criminal investigation. I guess the question is, what should govern, in your opinion, when CSIS shares information for criminal purposes, or if there's a competition between collecting further intelligence where early revelation of criminal evidence could jeopardize the intelligence work that's being done, which interest should prevail, the collection of evidence or to obtain a conviction, or the collection of intelligence for future purposes?
I'm not an expert in this area, but my observations over the years is that CSIS does not collect evidence. CSIS collects security intelligence, and part of the justification for destroying the tapes, for example, in the Air India thing, was that it was an old RCMP policy that tapes should be destroyed after 3 months because they contain personal information about individuals, and it would impact negatively on the privacy rights of the persons being targeted. So there are conflicting policies at work here, but I'm still of the view that if you can provide some sort of separation between collection of security intelligence and collection of evidence, if you, in your security intelligence work, stumble across information that looks like it should or could be evidence that would be useful to the police, and then you hand it over to the police, then that must be disclosed. And under the rules of disclosure and Stinchcombe. But I think the Supreme Court of Canada maybe went a little far in Charcouy of suggesting that everything that CSIS collects even if it's not going to be used in evidence, if it could possibly ever conceivably be used in evidence, then it has to be, they have to retain it and they can't destroy it. And it's created all sorts of operational difficulties. So if you read the Supreme Court of Canada in Chicago 2 and set that alongside the judgments of Fletcher Dawson in the Toronto 18 case, you see a dichotomy existing between the two. I would side with Dawson, and I think he's drawn a practical line between the two so that they can work together.
Yes.
So in your comments, you referred to Mr. Lapine, who the Montreal Massacre, as a terrorist. So I was wondering, based on that kind of, those classifications have also been used by members from the Conservative government over the past 5 years. So my question is, at what point does someone become a terrorist instead of just a criminal? And at what point should they be subject to these intense provisions that have been as part of the Terrorist Act?
That's a good question. I mean, when does a mass murderer become a terrorist is what you're asking. And if the mass murderer inflicts damage not only on a widespread number of people, but in a society as a whole, intends to intimidate for a particular cause or purpose. Take the example of the alleged gunman in France this past week, who's apparently using the same weapon in a number of cases against the Jewish community, against the military community, and everything. But he's been now labeled a terrorist by the French authorities and this sort of thing. And I think it's probably achieved that level. But I don't think you can draw a fine distinction between what is just a mass murder and what is an act of terrorism, except the notion of widespread public concern and intimidation. That's the best I can do.
I don't have a microphone, but do you think do we need the label?
Lone wolf terrorist?
But do we need to call them terrorists? I just don't know what value is added. And then we end up in these protracted disputes about what is terrorism. We see it going to the Supreme Court now on, Rutherford validating the religious motivation component. We get bogged down, and it's clearly a serious crime. Kawajo's not going anywhere, whether he's a murderer or attempted murderer or a conspirator towards murder or he's a terrorist. He's not going anywhere. Why do we need the label? And given how it can be politically exploited.
Yes, it can be.
I mean, you see in the Arab Spring, all of the regimes that have been challenged almost immediately labeling the political dissidents as terrorists because it's such a powerful tool. And we facilitated that by nourishing the notion that terrorism is somehow different and extra legal and allowing these legal black holes.
But I can agree with you 100%, James, but I guess the train has left the station. The term was not invented in Canada, and we're just latching on.
Johnny?
Yeah, sorry. I have to excuse my English every time.
He's from Iceland.
Okay, got that out of the way.
We think he's here as a spy, but he's pretending to do graduate work.
Good to clear that also. Okay, I always find it interesting when we talk about information sharing, and it always goes to that torture issue, which sometimes, in my opinion, spoils a little bit the discussion, because there are other issues that are important than only this big issue. From where I am looking at organized crimes, information sharing tends to be a problem because we have different jurisdictions, and there are different rules about how to obtain evidence and or information and how to use them. So if you obtain them in one system and use them in another, there is already a problem, even if it's not as fantastic as the torture issue. So I was wondering if you could reflect a little bit upon that, and if I may also ask a little bit small question of interest to me, because you talked about holistic approach to national security, talking about disasters from many forms of disasters, including terrorism and national disasters. Would you consider to include organized crimes, transnational organized crimes, for example?
Well, I'll answer the second question. The answer is yes. I would include organized crime as a form of a threat to national security. I think we don't have a major threat to national security, but we have a threat. I think if I were in an equivalent position in Mexico, I might see organized crime as a major threat to their national security, just to give you an example. On the other question of information sharing, it's a complex one, and I can only deal with it by giving examples. They said, you know, we share information. I think it's something like 160 countries. We have 230 agreements, and some countries that might surprise you: China, Iran. That we share information with, a much limited extent than with the United States, Europe, European countries, or others. But I was 2 or 3 times ago in China in the spring of 2008, just before the Olympics, and talking with law students and about terrorism and this sort of thing. And they said, well, what advice have you got for us in terms of what we can do to prevent terrorist acts? And I said, well, I'm hoping that the world intelligence community is opening up in terms of sharing information about people intent on causing difficulties and disruptions at the 2008 Olympics. And just as we will share our information with you if we know a terrorist is getting on board a plane in Vancouver and is headed your way, when you have somebody get on a plane in 2010 in Beijing and headed towards Vancouver for our Olympics, we'll share that information and try to prevent it. And I think there was considerable information sharing went on between the Western countries and China in 2008 and 2010. And that's different than sometimes sharing information that, and China, of course, engages in torture. There's no question about that. Do we not tell them about certain terrorists that may be coming their way? I think what we did share with them, and it's what widely known now, is not only who might be coming their way that may be dangerous, but the biggest threat of terrorism with the Olympics Games, whether it's 2008, 2010, is the torch parade. And the torch parade, whether it was in Tibet or whether it was in Newfoundland or what part of the country, there will always be people using the domestic torch parade to protest a particular cause or make a particular point. And I think we're going through the sharing of information right now with our friends in the United Kingdom as they prepare for the London Olympics in 2012. And so it's sharing not only information as to who the individuals are, but the operational techniques that are used in dealing with the torch parade. And I think the British, if they accept the advice that they're getting, I know, from many other countries, will run their own torch parade, and hopefully it will be reasonably terrorist-free.
Could I just ask a question that maybe if I'd looked at the whole of the Aurora inquiry instead of just the parts that I thought to read, I might know the answer to this. From your experience, how the role of CERC, do you think, has that changed over the years since you were director? I mean, when we read about it, what seems to be so unique as opposed to, again, to anything that the RCMP has, is that CERC has a mandate to actually allow themselves to be involved or to be aware of what CSIS is doing. How involved is CERC in the operations of CSIS?
Well, it's like so many things. How do you define a particular cabinet position? It depends on the individuals occupying it. And some people are more aggressive and more ambitious than others. And there have been good chairs of CERC, and there have been not so good chairs of CERC. I can just give you the example of going back in my day, and my successor after 5 years was the late John Bassett, who was head of CTV. who's a big, gangling, gregarious sort of guy who couldn't keep a secret. And he couldn't avoid talking about all this stuff that he knew about in a context that would not reveal stuff that he shouldn't be revealing. So he was a terrible chairman because of that inability. Now having said that, I think the CERC operates within a defined statutory mandate. It's there in the law, and it's protected, and the independence is established, and they're the two benefits they have is, first of all, they have absolute access to all information that CSIS has, except cabinet confidences. So that's everything so they have to look at it and see it, and CSIS can't deny it. Second thing is the organization itself, CSIS, accepts CERC and the prospect of review as being better than the alternatives of court intervention or ministerial intermeddling and this sort of thing. And that successive directors of CSIS have said, you know, we have a good working relationship with CERC and we don't mind review. It makes us a better organization. It's kind of like student evaluations, you know. Professors have to put themselves through this, but do they become better professors as a result? And some would argue yes, and that's obviously the objective of the exercise. So RCMP has this mindset that they're officers of the peace, and we're not above the law, but always we have our own law of policing, and that's another subject.
Another question? Yes.
In your remarks, you just mentioned very briefly the information sharing between specifically Canada and the States as it relates to the new security border.
Security perimeter.
Yeah, security perimeter that's in discussion. Can you just talk a little bit about potential ramifications as to having someone who has security laws that are so different from ours in terms of...
Well, it's not just a proposal, it's a done deal. And with the Department of Homeland Security and with our Minister of Public Safety and with the two governments, from President to Prime Minister. And it's essentially, in terms of the security perimeter, it's North America. And the ultimate goal may take 2 or 3 or 4 years to achieve is that we're going to have the same rules whether you go to New York or Toronto. If you're coming in from Europe, in terms of security screening, in terms of surveillance, in terms of land crossings, what have you. And this is being sold as something that will facilitate two-way trade between Canada and the United States, which is $2 billion a day. I mean, it's huge, and their biggest trading partner. And it will facilitate trucks going in bond from their shipping warehouse from Toronto down to New York, and save time at the border and all the tie-ups. And so all the business groups are in favor of this. But there will be a price to be paid by individual citizens in terms of the rules, which will be established primarily in the United States. We're consulted, but it will be primarily the U.S. And the invasions of privacy that some of us may have to endure. I don't know that you've been through the airport recently and gone through one of the body scanners.
I got patted down.
No, they go through the body scanners. They're quicker, but some people do regard them as an invasion of privacy. I think it's a price we have to pay.
Over here.
So you said that's a done deal. I'm not really sure how many of the details have actually been hammered out, but going back to what Ian was saying about the ramifications, what do you expect in terms of information sharing? Is it going to be CPIC just dumping all their CDs and discs over to the U.S. like we saw with Arar, or what's the information sharing going to be?
I think the information sharing will be more extensive, but I think the checking of the information to be shared will be also greater. And so let's, within the RCMP, let's avoid another Arar where we just give it to them unvarnished. There was evidence that came out in the Arar Commissioner from the Deputy Commissioner after he was describing the situation and the mood that prevailed after 9/11, and he said, all caveats are down. And caveats are information that you usually attach, but it can go to this agency, but not to this agency without our permission. And the RCMP took it literally. All caveats are down, and they just dumped everything out across. And we'll do what we have to to protect our way of life in North America. And it was sort of a mindless list. And CSIS, with the complicity of the RCMP, embarked on that course, and the Department of National, the Foreign Affairs. But I think there is greater care taken now in the information that to be shared, and there are people who are paid to vet this stuff and see what should be excluded or redacted.
But in terms of not just intelligence sharing for combating terrorism and particular threats, but just for the average citizen, are you going to see like PIPEDA just kind of washed aside because you're saying the U.S. is making the rules? Is the Patriot Act now the standard in terms of ability to collect information, and it makes PIPEDA sort of meaningless in that the average Canadian citizen's information is not as
It's a good question,
worthwhile.
but I don't think it will make it meaningless, but I think it will reduce its effectiveness.
PIPEDA has some pretty broad exceptions for policing and national security, and I'm sure they're going to just drive all of this information through those exceptions.
That's right.
And I think already Canadians' police information computer printouts get uploaded. If you're charged, even if the charges are withdrawn, I've heard of people who are confronted by the American authorities saying, you were charged with, even though you were convicted.
Without ever going to the States in the first place?
Well, if you're going to the States, it's when they find out at the border.
Mm-hmm.
This charge of possession of marijuana, what was that all about? I wasn't even convicted. You know about it.
Would a post-Harper government make any difference, or is the juggernaut on its way and can't be returned in terms of the perimeter, in terms of those kinds of agreements with the United States?
The latter, because the perimeter agreement was under negotiation with the Martin government before Harper came along. It's something that's been 1965 or 2005, 2006.
So no matter who comes in, that will be...
Not unless, as we have, there's a major incident. And, it's a major invasion of privacy. We still have...
Maybe if Craig becomes Prime Minister.
We still have discrepancy. Or if Craig goes to take his first trip to Washington as an MP and finds he's on the no-fly list, and then there could be an issue.
It's a real possibility with Craig.
Well, that happened, the story about there was a person on the U.S. no-fly list called Edward Kennedy. And the late senator was stopped at the airport in Washington and told he couldn't go on the flight because he was on the no-fly list. It was another Edward Kennedy, but it took him a while to get off. Yeah. So it's, again, always easier to get on than get off.
Could I just ask one quick, somewhat earlier in your talk, you were saying that in answer to James' question, did we actually need to have an anti-terrorism legislation? And part of the explanation, or the Canada's justification, is this idea that that it's symbolic, but that also, in terms of being a good neighbor, the United States really was fairly insistent that Canada be seen to be doing something. But then when James or somebody was asking in terms of later legislation, you seem to sort of be a bit critical of Canada marching along to the tune of Bush and now Obama in terms of torture, that kind of thing. And I'm just wondering, I mean, maybe the slippery slope was, maybe we should have said after 9/11, Canada is Canada, and maybe we don't need it. Like, if we keep sort of appeasing, then in fact there's no limit to what will be required of us.
Margaret, it's a good question, and I can't compare the two periods of time. If you go back to the fall of 2001 and the mood that prevailed at that time, and what we had to do and what we should do, and the general perception among the political and policymakers, with a few law professors like Kent Roach in dissent, was that we needed more heft. And that's the term. We needed more heft in our legislation, and the Americans would expect it of us. And so that's what occurred.
Yeah.
You're taking 2012, and here we are, and I think we have still some concerns, but not immediately in terms of aligning ourselves with the Americans on anti-terrorism. And I think it's generally making the North American continent work. And it has an economic dimension to it, and that's how it's being sold. But there will be a terrible price to be paid in terms of privacy and realigning our laws and regulations with the U.S. And it's the first exception that occurs when somebody's privacy is invaded unfairly, and it becomes an incident. Yeah. Then I think there will be greater public focus on it. But so far, I've read the public as accepting the necessity for a perimeter agreement. But if somebody wanted to embark on an area of study for the next 5 years, it would be a good one to see how this plays out.
Okay. A final question? A final question, going once, going twice. Then, Ron, I thank you very, very much for the informative session.
Pleasure.
Thank you very, very much.
Have a good year. And get out there and enjoy the weather.